Kusha Kapila just secured more than 50 crore rupees for her startup in a fundraising from a venture capital fund. Now that is some serious money. But what if this serious money goes to a wrong bank account? Now you might think that how can the money go to the wrong bank account? But let me tell you, as a corporate lawyer, in my experience, I have seen this happening multiple times. But why does this happen? How does this happen? And what is the consequence of it in law? Is what we will discuss in this video. Alright, first thing first, when I say wrong bank account, I don't mean that the money gets transferred to some third person or third company. It goes to the right company, just in the wrong bank account. Now, in order to understand this, you need to see section 42 subsection 6 of the Companies Act, which very clearly provides that if the company is issuing securities and taking money in return, then in that case, the money has to go to a separate bank account than the general bank account of the company. But there have been several cases where founders, despite doing everything legally correctly, somehow happen to ignore this provision or completely just forget about it, and they do not open a separate bank account for this purpose, and they take funds from the investor in the company's main general account, and that is where they get into a non-compliance. The consequence of this non-compliance is a penalty, which in certain cases can be exceptionally high and can be simply avoided by opening a separate bank account and putting their funds in that account. And yes, this was the legal insight for today's video. If you like such legal insights where I break down corporate law as regards to fundraising, then consider following for more.